Today we'll be discussing how an obscure concept in bankruptcy law known as the nonconsensual third-party release is holding up the multi-billion-dollar settlement between the Sackler family, Purdue Pharma, and the victims of America's opioid crisis. Hello and welcome to TalksOnLaw. I'm Joel Cohen. Today we're joined remotely by an expert in bankruptcy law, Professor Edward Morrison of Columbia Law School. Edward, thank you so much for joining today.
It's good to be back.
Usually in bankruptcy, we're talking about money and jobs, and these are critically important. But in this case, it seems like, at least to me, there's a lot more at stake.
Well, yeah, we're dealing with sort of the convulsions arising from the opioid crisis. Purdue Pharma is the topic for today, and Purdue was a major supplier of one of the most commonly used opioids called OxyContin. And Purdue Pharma admitted to criminal liability arising from its deceptive marketing of that drug twice, both in 2007 and again over a decade later in 2020. And Purdue admitted to marketing its drug to physicians who were writing illegal prescriptions, lying to the DEA, and paying kickback to physicians in order to induce them to write more prescriptions. So in the aftermath of that revelation of news of Purdue playing such an important role in deceptively advertising a very addictive drug, the mountain of lawsuits arose both against Purdue and against the family that has owned Purdue since the 1950s, and that is the Sackler family.
That's important to today's conversation, which is that Purdue wasn't a publicly traded company. It wasn't owned by thousands or millions of shareholders. It was a closely held company controlled by one family.
And it's alleged that that company played a role in the illegal marketing schemes and potentially also taking assets out of the business that should have been left there. These are all allegations that were the basis for lawsuits against the Sacklers separately from the company Purdue that they owned. But those lawsuits were stopped when Purdue entered bankruptcy.
And I guess today what I really want to talk to you about is whether or not, and under what circumstances, if so, a company or individuals can use bankruptcy court to give themselves kind of a blanket protection from claims of pretty astounding level of negative impact. What's the legal term that we're discussing here?
Yeah, it's got a technical name called a non-consensual third-party release or settlement. And I can just break down those words, but then we can talk about why it's both controversial and a development that has grown. These are not, first, it's not new. These kinds of settlements have existed at least for about a couple decades, as far as my understanding. You can find cases at least a decade ago in which these have occurred. And what happens is that a company will enter bankruptcy. It will be liable. The reason it's in bankruptcy is because it owes a lot of money to its creditors. And these creditors could be individual victims, as in the case of Purdue Pharma. They could be bondholders. They could be employees. They could be tax collectors. But oftentimes the company enters bankruptcy. Those creditors realize that they're owed money by the company, but they could also bring suit against the owner of the company who may have played a role in the bad behavior of the company, or because the owner may have actually agreed contractually to indemnify. And that's just a word to say that the owner has agreed to pay creditors in the case the company can't. That's common. Now, in most cases, the owner of the company is just another company. So you have a parent company and you have a subsidiary. The subsidiary enters bankruptcy and the creditors of the subsidiary want to sue both the subsidiary and the parent. That's the more common framework that's we see out there. In the context of Purdue Pharma, it's Purdue is entering bankruptcy and the parent, there really isn't a parent company. There's a family that owns Purdue and there are lawsuits against them. Now, the bankruptcy is about, in the abstract, bankruptcy is about bringing a company into bankruptcy and restructuring the debts. Basically, if the company's going to survive, it means reducing the debt to a level that's consistent with an ability to pay by the company. And it's very common when a firm enters bankruptcy for there to be tons of uncertainty about what is owed to the creditors, whether it's liable to creditors, what's the amount that's owed, whether the firm has counterclaims against these folks. So there's a lot of uncertainty. And so it's very common in the context of bankruptcy for there to be settlements. So the firm that's in bankruptcy will settle a dispute with suppliers, employees, bondholders, and that'll be part of the bankruptcy process, is settling the disputes. You might say, what's the alternative? The alternative is that in bankruptcy, there is a procedure by which you can have a trial, a form of litigation. It's called an adversary proceeding, but it's just a miniature trial that can be had in the context of bankruptcy when there's uncertainty about who's owed what. But like in life, most lawsuits are settled out of court, and that happens in bankruptcy via what's called a settlement. Now, if you have a settlement between the company and its own creditors, you might call that a first party settlement, okay? But what if you have a settlement that is not between the company and its own creditors, but between those creditors and someone else? Maybe the parent company, maybe the Sacklers.
Yeah.
That's called a third party release, because what you're doing is you're settling litigation by creditors against somebody who's not in bankruptcy right now. So you get that distinction. It's the same creditors. We're always talking about the same creditors. If these creditors settle their claims against the firm in bankruptcy, that's an ordinary settlement. You might call it a first party release. But if you're settling the claims of those creditors against somebody who's not in bankruptcy, we call that a third party release.
Yeah. And in this case, the Sackler family isn't facing bankruptcy. I mean,
So let me break down one other piece, is that it's called a non-consensual third party release. So it's called a third party release because you have a deal in Purdue's bankruptcy that is settling liability against the Sacklers who are not in bankruptcy. So that's the first dissonance that you might feel, is that like, wait, how can a bankruptcy court resolve disputes against somebody who's not even in bankruptcy?
Yeah.
Right, go figure. Okay, then we add another layer, which is that, well, if everyone in the bankruptcy thinks, yeah, this seems like a good idea, we should release our claims against this third party. Generally we have a rule that if everybody agrees to do something, it's a free country. They can do that too. It's like freedom of contract, that in bankruptcy, if everybody agrees to do something, we can do that. So you might say, it's no big deal for a bunch of creditors to say, hey, we're going to give up claims against the Sacklers because we all agree to do that. In this particular case, it's non-consensual because there are some creditors who have said, no, I don't agree to this. I want to pursue my suit against the Sacklers in a state court, in a federal court, maybe a court abroad. But this settlement in this particular case is saying to the creditors, hey, we're settling the liability of the Sacklers to you, and you have to accept this even though you do not agree to it. And that's what makes it non-consensual.
And
okay, sorry.
No, not at all. I was just going to make the much less erudite point that the Sacklers aren't bankrupt. They're quite wealthy. In fact, a number of them are on the billionaire list. But to your point, I mean, not only is it there are listed creditors, but there's also people who might not know about the lawsuit. Maybe someone who's serving time in prison for something related to their opioid addiction. Or I guess where I'm going with it is it's not just people who own shares in Purdue here that are going to be lose legal recourse, but those involved in personal injury, wrongful death, torts.
Yeah. Well, how about we do this? Why don't I set up the story about why this settlement should bother you? Okay, I'm going to give you the facts because you keep peppering me with these facts. So why don't we just own them? Let's put on the table why the settlement should make you feel, or at least make you do a double take. Like, does this make sense? And I will tell you why I think it completely makes sense. Okay, so that's my punch.
Okay,
we'll get there second.
I'm in with your framework, Professor.
But this settlement has a lot of uncomfortable features to it. One is that the Sacklers never filed for bankruptcy. They did not suffer the embarrassment of that. They have not been hauled into a court in federal or state court and been deposed, cross-examined, and subject to that day in court that many victims want. Okay. Instead, the Sacklers are benefiting from the fact that their company is in bankruptcy. They're not filing, but their company called Purdue Pharma is there. And that bankruptcy has a certain feature, as do all bankruptcies. The bankruptcy of a company brings all creditors into one court. It's like a massive class action, a massive multi-district litigation. It's more powerful than those devices because everybody has to be there. Everyone's there, and the Sacklers are benefiting from the fact that everybody in the world who can sue them is there.
And this is part of the magic of bankruptcy. I mean, it's not like in normal courts. It's got some broader authority for fairness that we don't see.
We'll get to that in a second, but the key is that the filing of a bankruptcy creates an automatic stay that stops all litigation against the company. There's actually some authority to extend that automatic stay to stop suits against third parties whose liability is closely related to the firm in bankruptcy. But let's put that to one side. Then, so far you get the pieces are that the Sacklers they didn't file for bankruptcy. They were never hauled into a state court and had the embarrassment of a cross-examination. Instead, they're taking advantage of the fact that Purdue is in bankruptcy, and while there, the Sacklers are offering money to make this problem go away. So they're saying, we will give you money, all you victims, all you state, tribal governments, if you agree never to sue us. And so they're offering money for a release of liability. And the bankruptcy court issued a decision approving that deal, money for a release. The district court reversed, but on appeal to the Second Circuit affirmed, saying, yes, that deal is legitimate, and now it's going to the Supreme Court. Now, but partly the last piece that should make us uncomfortable is the fact that this release, if it's affirmed, if the decision of the Second Circuit is affirmed on appeal to the Supreme Court, it will release the claims against the Sacklers and prevent certain aggrieved parties from suing the Sacklers, even though they never agreed to this deal.
Right.
That's the non-consensual part. That a lot of people agreed to this deal, but some did not, and they're getting iced out. I'll stop there, but my punchline is that discomfort, I think we need to check ourselves that, yes, at an abstract level, all that sounds bad, but we actually have to think about what were the terms of the settlement, and we'll talk about those, and what was the alternative. And you have to say, the perfect cannot be the enemy of the good. And it might be the case that this settlement is better than any alternative that's been proposed.
You mentioned the settlement. Why don't we just jump into the weeds of what's being offered or what was agreed upon before the Second Circuit made its opinion, and then we'll talk about why you think it actually makes sense.
Part of the reason it might make sense is just to talk about the details. That after filing for bankruptcy in 2019, you might get the impression that the Sacklers showed up and said, hey, here's some money to make this problem go away. And victims felt, gosh, I don't know what to do, or states just agreed and it's all over. And here we are. No, it has nothing like that, not at all. What happened is that they had a bankruptcy filing followed by, if I remember correctly, the Second Circuit says months, but I think it might be well over a year of mediation efforts where they brought in representatives of the Sacklers, Purdue Pharma, all the victims, and again hashed out what deal would make sense. Just to give you one example, the Sackler family originally proposed to give slightly more than $4 billion as their contribution to avoid civil liability arising from the claims in the bankruptcy case. That went back and forth, and it's now close to $6 billion. So what you had is a process of pushing back on the Sacklers and not only increasing the amount of money, but the terms of the settlement, after lots of mediation, lots of back and forth, included the following. For example, there's money coming in from the Sacklers, but roughly about $10 billion is going to be paid out to victims. I have some notes here that you have various trusts being created for the benefit of governments and victims to deal with the aftermath, not just to compensate victims, but to deal with the aftermath of the opioid crisis. turning Purdue itself into what's called a public benefit corporation, where it's no longer being run to maximize dividends to shareholders, but instead to fund public health initiatives. There is a repository of documents. I want to say it's like 10 million pages of documents made public so that anyone in the world can find out exactly what was discovered in the course of this bankruptcy, so that in some sense that victims can unearth the truth. And there was a hearing in which the Sacklers had to hear victim testimony. Some have said, and I think this is true, as my understanding is that that the victims had, in some sense, potentially more of a right to be heard here than in many mass tort cases that are resolved by multi-district litigation, for example. So those are the terms. But there's one other thing to keep in mind is the Sacklers, you might have this image that they're like in some small town in upstate New York and you just go sue them. It doesn't work that way. My understanding is they're located all over the world. And I don't know how many are even living in the United States anymore. And a lot of the wealth is in trusts located around the world. And so you have to think about the fact that this creates a double problem. One is that mass tort litigation is extraordinarily expensive. You have lots of lawsuits being filed, each of which generates a lot of litigation costs. But in this case, it's even harder to reach the defendants and the assets given their location all around the world. And so when you evaluate the terms of the settlement, you have to think about what's the alternative. The alternative is you throw the settlement out and you say to the victims, go ahead, have your day in court and have fun, because it's going to be really costly to pursue all of these lawsuits. So there's the courts below concluded that not only did they think the settlement was fair, but it preserved a lot of value that would be burned up by individual lawsuits against the Sacklers.
So if I could ask, Professor, am I right? You also have a PhD in economics?
Yes, sir.
So maybe let's, I guess, put on the economics hat for a minute. Is part of what you're saying that the transactional costs of going about it the other way would be so high that this is just the best way to harness the maximum funds for the victims?
I think that's exactly right. I think the courts below found that in some sense, as an economist, I just need facts to evaluate that. So you might say, as a matter of theory, of course, that like we could imagine that an aggregation in bankruptcy can avoid costs of litigation that would occur otherwise. Bankruptcy has important advantages relative to, say, thousands of lawsuits with their own costs. It has advantages relative to class actions, because class actions are limited by that principle that you can't have a class action if individualized issues such as causation and damages predominate relative to the common issues, which would probably almost surely be the case here, because the injuries vary so much by victim, and the victims are both people, governments, health insurance companies, hospitals. So the possibility of a class action that's not feasible. Multi-district litigation is an alternative, but that doesn't even capture, one, you can't bind opt-outs. Like in bankruptcy, you can force, if you have a large enough vote, all creditors have to go along with the deal. MDLs, multi-district litigation, they're not good at dealing with future victims. In bankruptcy, you can set up a device so that you can compensate future victims, meaning victims who haven't shown up yet. And multi-district litigation is federal. You can't capture state lawsuits. So there's a lot of advantages that bankruptcy brings in terms of bringing together lots of lawsuits and avoiding all the legal costs, those transaction costs you just mentioned, and thereby preserving value for victims that would otherwise be, burned up.
Maybe one data point to backstop what you're saying is that initially, when the bankruptcy judge decided the case and accepted the settlement, there was an outcry from a number of states. I believe it was 6 states plus the District of Columbia. And then by the time it was about to be reviewed by the Second Circuit, they had come on board. Am I right there? That's
correct. That's a really important point to keep in mind, that that the deal, which as in any bankruptcy, there are a lot of deals and they're put into a plan of reorganization, and then you take votes. And so one measure of a settlement like this is how how popular was it? How much dissent was there? And the numbers are pretty important, and they were very important to the Second Circuit too. The Second Circuit has, one of its. We'll talk about this. They have a checklist of principles that have to be observed if a court is going to approve a settlement like this. But one of the things that courts care about is, was there overwhelming support for this deal? And I'll just give you the numbers and you can tell me if it's overwhelming. We know that 95% of victims who voted in favor of the settlement. Now, so there's a thing, like, not everybody has to vote. So it's like an election. Like, you have a franchise, you can vote. But of those who voted, 95% of victims favored the settlement. Over about 80% of states and territorial governments approved it. 96% of tribal governments and other governments approved the settlement. And I think that the overall aggregate across all victims, individuals, states and territories, tribes, and the hospitals, that it's about 95%. I think it's a 95% vote in favor. One is that it shows that I think that counts pretty much as overwhelming support. But two, it gets to the idea that this settlement, that I said, should give us pause. It has a lot of features that feel uncomfortable. Nonetheless, that settlement was reached after years of discussion and mediation, going back and forth, to the point where 95% of those owed money felt it may seem uncomfortable in the abstract, but it makes sense to us in the concrete.
Did it raise any concern to you that most of the creditors didn't vote? Is that normal, or is that?
Well, I mean, one is that it's common for creditors not to vote. This goes to your due process points. The real question is why didn't they vote? Did they not vote because maybe they didn't know? You gave the example of the inmate who may not have known, therefore didn't cast a vote. Or did they know and maybe even received a ballot and chose not to respond? We know that happens a lot in bankruptcy, but it happens a lot in life. Like, take votes that corporations take on, their charter, all of us have received in the mail notices of a board meeting in a company we've invested, and how many of us actually look at the vote and cast a vote? Yeah,
I imagine many people don't even open the envelope.
I confess I shouldn't say go straight to the garbage. It goes straight to the recycling bin, okay? I don't take a look. I think the real question, as a matter of constitutional law, is whether due process was observed. And the principle, of course, this could get, reevaluated before the court, but the general principle is that it's notice reasonably calculated to alert the person with the property right or the contractual interest or the right to sue. And I think in the courts below, the Second Circuit and the Bankruptcy Court, believe that the very public nature of Purdue and the information that was sent out was reasonably calculated to put people on notice. And yes, maybe it wasn't perfect, and that's why the standard is reasonably calculated, that we can't demand perfection.
Well, I guess, Professor, the thing that gives me pause, or the concern that I suppose is that we don't want a situation where a company or a billionaire realizes that they've got this liability that is likely to wipe out all their wealth, and instead uses one of their companies or a company that they're affiliated with, funds that to some degree in a way that enables them to get this protection. I think that's the concern that I feel.
No, I think that's a real concern. I think that it's a tool that, what are we talking about? We're talking about the fact there's a pragmatic reality that when a firm enters bankruptcy and the creditors are owed a lot of money and all the creditors are there's this great temptation to say, hey, let's not lose this opportunity. If everyone who's owed money is in one room and they can sue someone else, let's use that leverage to extract a settlement from someone else. Like, it's, yes, like we can, we're here to deal with the firm in bankruptcy, but we're all here and we may also have a claim against someone else. So let's use our leverage. We're here. That's good for us. It's also potentially good for the defendant to avoid lots of lawsuits. So it's a useful tool that the Sacklers are benefiting from, and so too are the victims, or at least 95% of those who voted. But like any tool, it can be totally abused. And it can be used, you're right, it could be used nefariously by a family or a parent company that strategically puts its subsidiary or firm into bankruptcy in an effort to extract a settlement that, and may put, I don't know, we could talk about it, but there may be ways to put pressure on the victims to make them feel that they have to do this. This is why that it is vulnerable to abuse. There's no doubt about it. So there are lots of devices in bankruptcy that are designed to achieve efficiency. And you might say that's what's kind of what we're talking about, is that a deal with the Sacklers in bankruptcy is more efficient than a multiplicity of suits outside of bankruptcy. And the real question is that, okay, we want that efficiency to be beneficial to the victims. We don't want it to be something abused by the perpetrators. So how do we make sure that this efficiency is for the benefit of the victims and not something that perpetrators are using to their advantage to bully victims? And that's where the Second Circuit comes in. That is a multi-factor test. It's got 7 factors, but that are designed to assure the court and the world that this release, that this case is one of the very special ones where the efficiency benefits are powerful and the risk of abuse is minimal.
Yeah, Professor, why don't we talk through those 7? I don't know if you have them off the top of your head or if you've had some notes.
I can describe them in broad brush.
Sure.
Okay, so I think the most important thing to keep in mind is that the Sacklers are not getting released from any and all lawsuits that a creditor or a victim could bring. They're only getting, like, first, they're not being released from criminal liability. No bankruptcy court can do that. Okay, so, and there are potential criminal actions that could be brought. Okay, so that is off the table. Secondly, it's only releasing claims that the creditors or the victims could bring against the Sacklers that is also a claim that could be brought against Purdue. So deceptive marketing, that the Sacklers' participation in that. If there was some separate wrongdoing by the Sacklers that is where the facts of that wrongdoing are separate from anything going on at Purdue, the victims can go after them. So that's one of the factors, is that there has to be a close nexus between the claims against the Sacklers and the claims against Purdue, so that there's sort of a common set of facts. As the Second Circuit, I think, said it, you basically have to be in a situation where a suit against the Sacklers is basically a suit against Purdue too. So there's this commonality. So that's one way of kind of narrowing the release. Secondly, that you want to make, I'm skipping over. I'm not going to name all 7. So I'm going to say that that's one constellation of factors, is the suit against the Sacklers is very analogous to a suit against Purdue. There's a commonality of facts, a commonality of interest. Another group of factors is that the settlement is essential to maximizing recovery to the victims, meaning that without this settlement, victims will do a lot worse, either because of the cost of pursuing the Sacklers, or the amount of Purdue itself could go after the Sacklers, and Purdue would generate its own legal costs that would reduce the amount of money available to the victims. So there has to be a sense that this is better than the alternative, that a settlement here that releases the Sacklers is better than what else could happen outside of bankruptcy. You want evidence that it's a big payment, that the amount of money that the Sacklers are paying is large. That's, it's hard to say in concrete, like, what is large, but the court felt that the roughly close to $6 billion that was being paid by the Sacklers was a large enough payment relative to the victims, what they're owed. Another one is that there's overwhelming support from those who are affected by the settlement, and that goes to the 95% threshold. And then there's another factor that just deals with the overall fairness of the settlement. Now, if you take a step back, these factors are, you might say, they're very loose. They're kind of abstract. They seem, you might say they don't seem very sharp, that they're potentially, depending on the judge.
There's room for flexibility.
Yes, and I think that is one by necessity, that it's, I think that we want to live in a world where we can make, okay, I'll say it in a different way, is that the perfect cannot be the enemy of the good. The perfect compliance with the bankruptcy code can't get in the way of the practical reality that perfect compliance with the bankruptcy code or some principles of justice would burn value. So like you might say that perfect compliance with the code might mean that, well, we can't release the Sacklers. If they want to get rid of their liability, they better go into bankruptcy too. But they're not, or it's going to be really hard for that to happen. So we have to think about, on the one hand, you might think that that we really don't want folks like the Sacklers to get the benefit of bankruptcy without going in. I think that's one key. Because you could say that the Sacklers are getting the benefit of bankruptcy, which is eliminating debt, without going into bankruptcy. So we kind of want to say that we don't want that to happen unless there are extraordinary reasons for going there. And that's what these 7 factors are about. Is like, do we have a set of extraordinary facts that suggest that this is one of those rare situations where it makes sense to give the benefit of bankruptcy without being there?
And, one of the things you mentioned was the alternative isn't more attractive to the creditors or to the victims. When we talk about the alternative, is it just financially, and is it just to the creditors that the court would be looking at?
Maybe could you explain more? Like, I'm not sure I followed the question.
Yeah, I mean, I guess when you were describing the 7-factor test, one of the things that you said the court will look at is, what's the alternative? Is there a better alternative? And I guess the question there is, better for who? Is the court allowed to look at more than just the numbers? Are they allowed to look at, perceived fairness?
That is a factor that courts will have to consider, and it's one that's that the cert petition filed in this case raises, which is that there are values, such as having your day in court, that may not be easily monetizable. And that's why I think in this case it's important to think about, there's $6 billion being paid, but the Sacklers are avoiding the embarrassment of a lawsuit or a bankruptcy. They're avoiding the day in court that the number of victims have wanted. And those things, how do we quantify how important those are relative to the monetary contribution? I think in this particular case, it's made harder because there was an opportunity for victims to express the horror that they endured. There was months of mediation that was analogous or got similar to what you might have in a courtroom.
Yeah.
And furthermore, again, it's kind of like relative to what? It's not clear to me that multi-district litigation yields much more in the way of a day in court. I'm not an expert in MDLs, but my sense is that those frequently don't give as much opportunity to be heard as the victims had in this case.
I guess maybe now's a good time to talk about the circuit split. So the Supreme Court has decided to hear the case. My understanding is that it's because the Ninth Circuit and maybe the Second Circuit here have a different view on how these non-consensual third-party releases work.
My understanding is that the courts that do not permit third-party releases often rely on the fact that the bankruptcy code does talk about these kind of releases. There's actually a provision in the bankruptcy code that actually authorizes courts to release claims against third parties, like the Sacklers. There's actually a provision that permits it. but it's only for asbestos. So one inference that some courts have drawn is that, well, Congress knows how to give courts permission to release third parties. It did so with respect to asbestos, and therefore it's not doing so with respect to everybody else. So that would rule out, in a court like the Ninth Circuit, a release such as the one you see in the Sackler or in the Purdue Pharma case. There may be other reasons that they cite for refusing to allow third-party releases, but I'm not really right now in a position to talk about that. On the Second Circuit side, and the courts who have approved third-party releases, they tend to view third-party releases as something that should be granted in very special situations. And that's why that we talked about that 7-factor test. As a matter of just authority, what these courts tend to look at is to say, yes, it's true that Congress gave authority in asbestos cases to give third-party releases, but that doesn't necessarily mean that Congress was precluding it in other kinds of cases. It's just that Congress, in some sense, created a safe harbor, that it's definitely permitted in asbestos, and it's possible, and I think there is a story, that the legislation was in response to the asbestos crisis. So what is the authority to grant third-party releases in the bankruptcy code? Well, at least in the view of the Second Circuit, it derives from the broad equitable powers that the bankruptcy code gives to judges. There's a section called 105 that gives these equitable powers to do what's necessary and appropriate to implement the bankruptcy code. And then Chapter 11 of the bankruptcy code says that courts have the power to do things that are not inconsistent with the rest of the code. And so one argument is that third-party releases are not inconsistent. So in some sense, even though they're not explicitly permitted by the code, there are provisions in the code that say you can do things that are not listed here as long as they're not inconsistent with what is listed here. And so that's a statutory hook, and we'll see what the Supreme Court thinks. I mean, I got to imagine that the Supreme Court's going to think that these provisions are incredibly broad, and that we wouldn't want these broad equitable powers to be exercised in an extraordinarily broad way. But there are lots of Supreme Court decisions that have come down over the years that have narrowed the powers of the bankruptcy courts. And I think also the Second Circuit 7-factor test is yet another way of trying to constrain that discretion. So I think that what we see, I think, in the Second Circuit and courts that approve these third-party releases is an effort to exploit or take advantage of the flexibility given to bankruptcy courts by virtue of these broad equitable powers, but to impose constraints that prevent those equitable powers from being used in a either abusive way or in settings that give you pause, that might make you concerned that these equitable powers might be used in ways that are potentially harmful to victims or other claimants.
It sounded like a bit of a prediction there. I mean, this particular court has a reputation for being relatively pro-business. Would you say that this would fall within that? Is that a silly question?
No, it's a good question. It's a really hard question. And I can only I can't even speculate very intelligently about it. I think that, yeah, there are these stories that the Supreme Court is business friendly. I don't think of this as I don't know if that's actually true, but even if it were true, I'm not, because I'm no expert. I'm not a Supreme Court watcher. I'm not denying or confirming whether that's true or not. It just I think that in this particular case, I think what the court is going to be concerned about is the power of the bankruptcy court and the power granted by the bankruptcy code. The Supreme Court has long been concerned that bankruptcy judges are not Article III judges. They're not. They don't go through the normal nomination and confirmation process that Article III judges do. They're nominated by judges on the courts of appeals, and they act as they have limited terms. So there's a lot of things bankruptcy judges are not Article III judges, and so there's a concern about bankruptcy judges exercising Article III powers. Now, that's not going to be an issue in this case because both the district court and the Second Circuit agreed that the decision in Purdue Pharma would have to be reviewed de novo by the district court and on appeal, so that in this sense that though the bankruptcy court is doing a lot of work, it's going to be reviewed afresh on appeal so that we can eliminate any concerns about a judge without Article III power exercising really powers that you think only a judge could exercise. So I don't think that's an issue. I think the bigger issue here, therefore, on the Supreme Court, I'm guessing, will be just whether you can do something that, like a third-party release that is not explicitly authorized by the code. So can these provisions, like I alluded to a couple of provisions of the code that give judges broad-ranging equitable powers, can those powers be so expansive as to do something like this? I'm not sure where the court will go. I could see the court saying it's not allowed, that you need express authorization from Congress to do something like this, that it's an extraordinary thing to take away rights of non-consenting victims or creditors. But honestly, I think that would be a huge mistake. I think that that's what I call perfection being the enemy of the good. That yeah, it might be in a perfect world, we'd have a explicit statutory hook for a third-party release. In a perfect world, we would get unanimous consent from all the creditors. But we don't live in a perfect world, and there is a real risk that even if 95% of aggrieved parties favor a deal, there's going to be a group or a small group that doesn't, and that group that holds out could be the difference between billions going to victims versus billions being burned up in litigation fees. And so I think that...
Am I right, Professor, that there's already been over $1 billion spent on the legal fees just in the bankruptcy?
Yeah. I mean, I don't know the exact number. I know it's in hundreds of millions of dollars. Bankruptcy is about compromise. Every mass tort, you might say any failure where you have lots of aggrieved parties, it could be Lehman Brothers, it could be Purdue Pharma, in any kind of case where you have thousands of people who are aggrieved and hurt, and some of them physically, as in the case of Purdue Pharma, you're going to have a diversity of views about what is fair. And we face this trade-off that how do we respect the individualized concept of fairness with the desire to maximize the recovery to victims. And I think that what we're struggling with in this country is that we don't have a good way to protect victims. We have an ancient model of litigation that is atomized, that individual victims are empowered to sue those who hurt them. And if it's you hurting me, that's simple. But if it's you hurting thousands, if not millions of people, that's a little harder. Yes, the ancient model is that every one of the million you've hurt has a cause of action, has a right to bring suit, and we want to honor that. That's an important right that our legal system gives to every one of those million. But if every one of those million brings suit, that's a million suits that are consuming resources, not just the victims hiring their own lawyers, but you defending yourself are burning, in some sense, burning up value. And those who sue first are, in some sense, going to do better than those who do later, who sue later. And so you have this worry that when there's millions of victims, you have that, in some sense, the costs you incur in defending yourself against the first few victims is coming at the expense of the later victims because you're running out of money, potentially. And that's a failure of our legal system, is how to deal with that coordination problem. He said there's this problem of having thousands of victims, each of whom has a right to sue. On the one hand, we want to respect that right. On the other hand, we want to recognize that, well, if we honor that right, early victims do better than later victims, and overall recoveries are lower because value is being burned up in all these lawsuits. And that's the motivation, as we know, for class actions and multi-district litigation, but none of those devices work the way bankruptcy does. And I think that's the fundamental discomfort we have, is that bankruptcy is in some sense the only device that has the power to bring all the victims into one place and reduce and maximize their recovery. And we're trying to, but it's an ancient balance, which is like, we want to preserve resources for the benefit of the victims. We don't want to take away their rights unless, like, we really want them to have the right to sue. We don't want to take those away unless it's really for the greater good. But that's what we're kind of balancing off, is the individualized right to the victim and the greater good. We have other systems that try to achieve that balance, but don't do it well. Class actions, MDLs. Bankruptcy is a new place to try to achieve that balance, and that's what we're seeing playing out. It's like this is the proving ground. Purdue is the proving ground, I think, in which the Supreme Court's going to have to say, does bankruptcy remain a viable option for achieving this balance? I think it would be a terrible mistake for the Supreme Court to say, no, you can't do these third-party releases. I think it'd be better to do what the Second Circuit is doing, which is to say, it's a careful balance. We're going to have to rely on our courts to strike the right balance, and maybe the Supreme Court can give us advice in addition to what the Second Circuit has given, so that this balance is struck in a way that makes us comfortable that, yes, we're taking away individualized rights, but the greater good is so powerful that it offsets that denial of individualized right. So I would like to live in a world where we have that balance, that it's still available to us, instead of being taken off the table. Because if you take off the table the ability of bankruptcy courts to achieve that balance and say that courts can't, well, there's no alternative that's effective. I mean, I guess you could say that someone could say to me, well, it just means that the burden's then on Congress to amend our bankruptcy code to make it possible to do third-party releases. But in the modern era of legislation, I think it's the real risky proposition to rely on Congress to make those kind of changes in a timely fashion.
And I guess if the Supreme Court, upholds the Second Circuit's opinion, do you expect to see more? I know, in prep for this, I was reading that Johnson & Johnson with their talc litigation is exploring a similar strategy. Is this something that you think will be a new model?
I do think Johnson & Johnson's different. So Purdue Pharma is a case where you had a company that's undoubtedly bankrupt. It's got billions of dollars of claims, millions of victims, like it's overwhelmed. And the only question there is that you have a company that's undoubtedly insolvent. Can we go after the shareholders for indemnification or to help to cover these costs because the shareholders
have money,
allegedly, participated in the scheme? Johnson & Johnson is a different one where you had like Johnson & Johnson is solvent, and it's got a subsidiary that I think was solvent. I don't remember the exact details, but it used a device to take a subsidiary and separate it into two, a healthy part and an unhealthy part. So the healthy part made consumer goods, and the unhealthy part had the talcum powder liabilities, and then it put that unhealthy part into bankruptcy. Now, so it's strategically created a subsidiary that housed all of the mass tort liability and then put it into bankruptcy. Now, that there is a parallel here, because what Johnson & Johnson is doing is trying to use bankruptcy to achieve the efficiencies that we're talking about. Like class actions, multi-district litigation are not going to resolve the talcum powder litigation in nearly as efficiently as a bankruptcy filing. And so Johnson & Johnson, in that sense, that it's very similar to Purdue in the sense that they're trying to take advantage of those efficiencies. But what's different is that Johnson & Johnson isn't bankrupt, and it created a subsidiary that was on the verge of bankruptcy, and to take advantage. So it's much more of you might say it feels much more strategic than the Purdue Pharma case, where you have an undoubtedly insolvent company and we got to do something about it. Whereas in Johnson & Johnson, basically you have, in broad strokes, you could say you have a company that's solvent, probably could pay all of its liabilities, but it's going to incur a lot of legal costs doing that. So it wants to save the legal costs by creating a subsidiary that it puts into bankruptcy that achieves the benefits of like a class action or an MDL. Interestingly, in that case, the courts twice now have said no, that's too strategic by half. And the real issue in that case is that this subsidiary that they put into bankruptcy wasn't insolvent, because Johnson & Johnson had said, well, we'll kick in money to the subsidiary to make sure the subsidiary can pay off all victims.
Yeah, it's a different.
They're trying to use bankruptcy to achieve its efficiencies,
Yeah.
and they're very explicit about it. Johnson & Johnson saying, we'll kick in money to make sure those victims get paid. We just want to conserve on the legal costs. It seems like a weird use of bankruptcy if you think bankruptcy exists only to save firms that are failing. But if we think of bankruptcy as conserving value in our society, it's a legitimate use, because you can conserve value through the advantages that bankruptcy has relative to the alternatives that are out there at the state and federal level.
Professor, do you think that the Supreme Court decision will impact the bankruptcy involving Johnson & Johnson and its talc baby powder subsidiary?
The Supreme Court decision could have an impact on the Johnson & Johnson strategy. That strategy, which has been rejected, that's why this is kind of a hard question. The Johnson & Johnson strategy has been rejected by the Third Circuit on the grounds that bankruptcy exists to save distressed firms, and Johnson & Johnson created a subsidiary that's not distressed. We're done. So that, in that sense, it's a very different case, but you could say that the Johnson & Johnson and Purdue are part of a family of cases where companies are trying to use bankruptcy as an aggregation device to bring lots of lawsuits into one forum. And that's what Johnson & Johnson's trying to do. That's what Purdue did. If the Supreme Court were to say that's not a legitimate use of bankruptcy, it's going to take the wind out of any effort to do what Johnson & Johnson tried, meaning that it would undermine efforts to use bankruptcy for that purpose. And I think that'd be a bad idea. I think that bankruptcy plays a key role in our society in conserving costs and protecting victims. I mean, that's what it comes down to, is that, bankruptcy can be abused. Everything we've talked about in this call can totally be abused, just like anything in life. Any tool can be abused. But this tool, called the release, the third-party release, used properly, can be an important device to give better protection to victims than they can receive outside of bankruptcy.
Edward Morrison teaches law at Columbia Law School. Edward, thank you so much for the time and this fascinating conversation.
Thanks, Joel. I really enjoy every visit to Talks on Law.